Welcome back again. In this subunit, we're going to try and distinguish between express conditions and promises when a contract isn't drafted clearly. So here's our setup. We have a clause in a contract and we don't know if it's an express condition or a promise. That's what we're dealing with in this subunit. So let's refresh our memories about why this is important. What is the difference between an express condition and a promise? Well, a promise, if a promise is not fulfilled, the party has breached her promise. The other party can sue for that breach. The non-breaching party can sue the breaching party for that breach. But the non-breaching party, the aggrieved party, can only refuse to perform her obligations under the contract if the breaching party has committed a material breach, not if the breaching party has committed a minor breach. In other words, promises need only be substantially fulfilled for the other party's obligations to arise under the contract. What about an express condition? Well, an express condition, if it's not strictly fulfilled, then it fails. And if it fails, the other party's obligations, the other party's corresponding obligations never arise. She's relieved of her corresponding obligations. So once again, promise, substantially fulfilled, and express condition must be strictly fulfilled. So if we have some sort of clause in a contract and we can't tell whether it's an express condition or a promise, what do we do? All right, let's look at some language we might use in a contract to signal to the reader and to the court that we're either trying to draft a promise or we're trying to draft an express condition. So first, let's look at the words that we might use to indicate that we are drafting a promise. Naturally, we might use the word promise. I promise to do something. Party A promises to do something. Clearly, that is going to be a promise. For some reason, lawyers don't like to use the word promise in a contract, and they use the word shall. So when you want to indicate that party A is promising to do something, you say party A shall, and then we have a verb. So party A shall deliver marketable title on October 12th. That is a promise. We could also use the word agree to. Party A agrees to deliver marketable title to buyer on October 12th. Those are both ways of drafting promises into contracts. Will is another way. Party A will deliver marketable title to buyer. Now, here's the thing. Lawyers rarely use will to indicate a promise in a contract. They can, but they usually use the word shall. Now, you can use will if you want, but the convention is to use shall to indicate a promise. Should. Party A should deliver marketable title to buyer on October 12th. Seems a little less certain that this is a promise. I think it's a promise. Should to me means ought to. Ought to indicates an obligation, but a lot of people look at should as kind of precatory. It's kind of a suggestion rather than a firm obligation. So don't use the word should in a contract to indicate a promise. All right, let's look at these words down here and see what words we might use to indicate an express condition. So party A has an obligation under the contract. Party A must receive an engineer's certificate stating that the land is suitable for her building needs. So in that sense, must indicates an express condition to buyer's obligations under the contract. What are her obligations? To buy the land. What is the express condition to her buying the land? She must receive an opinion or a certificate from her engineer stating that the land is suitable for her building purposes. So usually we don't draft party A must do something to indicate a promise. If you're not careful about drafting, and I've done it and other lawyers have, and you say that, hopefully the court will understand that that means shall. But once again, if you're going to draft a promise, use shall. Must is for condition. Naturally, if you say if, then that is probably drafting a condition. That's a signal that we're going to have an express condition. If party A does not receive the engineer certificate, then party A has no obligations under the contract, or party A doesn't have to purchase the land, whatever it may be. Conditioned upon, clearly that's an express condition. Contingent on is also an express condition. Not until, right? I have an obligation. I will not have an obligation until. That's also an express condition. Unless is the same as the if-then proposition. And naturally, provided however, right? So you draft something and then you say provided however, and then you draft the condition in there. So party A has an obligation to buy the land. Party A shall buy the land, provided however that if party A does not receive a certificate from her engineer stating the land is suitable for her building purposes by October 12th, then party A has no obligation to buy the land, right? That's how we would draft an express condition. All right, moving on now. Let's talk about what happens when a contract is ambiguous, where we can't tell whether the clause is a promise or an express condition. And first, let's go through an example and see why this can be very important. Why interpreting it one way or the other could mean the difference for one or both of the parties. So here's an example. Builder promises to build a house for buyer. The written contract provides XYZ brand nails to be used, right? Is this a promise or a condition? Well, before we discuss that, what happens? Well, because of a mix-up with supplier, builder uses another brand of nails and doesn't use XYZ brand nails. So the question is XYZ brand nails to be used, is that builder promising to use XYZ brand nails, or is that an express condition to buyer's obligation to purchase the house? Okay, if it's a promise, right? If we interpret XYZ brand nails to be used to be a promise, this is builder's promise, then builder has clearly breached this promise, but it seems like a minor breach. The facts say that XYZ brand nails are only of slightly lower quality, and that means builder has substantially performed her promise to build a house, right? Not using XYZ brand nails, that's just a small minor breach of the entire promise to build and deliver a house to buyer. So if XYZ brand nails to be used is a promise, builder has breached that promise, but it's a minor breach, which means builder has substantially performed, which also means that buyer must perform under the contract. Buyer cannot say, I am not obligated to buy the house because you have not used XYZ brand nails. Buyer may not say that if we interpret this to be a promise. But if we interpret this to be an express condition, XYZ brand nails to be used as an express condition, that express condition has failed. It has not been strictly fulfilled, which means buyer would not be obligated to buy the house under this contract. So we understand now why interpreting a particular clause as either an express condition or a promise is very important to both of the parties under the contract. What will a court say in this situation? Well, it's hard to say exactly what a court would say, but we have another maxim of construction. Remember our maxims of construction that we learned in an earlier subunit? When a court is construing a contract, it will use certain maxims of construction. And a new maxim of construction that we'll learn right now is this. If the language is doubtful about whether the clause is an express condition or a contract, or a promise, courts favor interpreting it as a promise. Now you might say, well, why is that? Well, express conditions are very, very unforgiving, right? Any little deviation from the express condition and the condition fails. Promises are more lenient. You only need substantial performance. Now, think about if you're a judge or if you're a contracting party, what do you expect the world to be? Just normally, you expect the world to be a little imperfect. And little imperfections in performance, well, we kind of expect that. I should be able to be compensated for that if you have an imperfection in your performance, but I shouldn't be able to say, I can totally walk away from this contract after you have substantially performed, right? That's the idea. And I use this in my class all the time, that we're not living in the world of magical fairies, where if you're not in your home by midnight exactly, and it's 1 second later, then everything turns into, you know, a pumpkin or whatever, right? We don't live in the world of magical fairies, right? So that's what we expect. Now, the whole idea of contract is that if you want to live in the world of magical fairies, you can live in the world of magical fairies, but you have to make that express. We don't live in the world of magical fairies. No one wants to live in the world of magical fairies. But if you do, if you want this part of the contract to be expressly fulfilled, and if there's even a slight deviation, you want to be able to walk away from this contract, then you better put that in the contract expressly. And if it's ambiguous, the court is going to interpret it as a promise and not an express condition. Okay. Now, what if you have some sort of extrinsic evidence? You say, well, in the written contract, it's drafted ambiguously. It's not clear whether it's a promise or an express condition, but before this, I asked the other party, is this a promise or an express condition? And she said, yes, oh, this is clearly an express condition. So I want to admit extrinsic evidence on that. The whole idea is go back to the plain meaning rule, and if it's admissible under the plain meaning rule, then it is admissible.